Ladies and gentlemen, it is April 14th, 2026. I am flying without a net, and this is the court gallery. What happens when a defendant challenges the very authority of the court? Today, we're diving into a court compilation packed with drama. You'll see a sovereign citizen deliver a lengthy speech only to be shut down by Judge Wiggins. And you'll also see a lot of people really upset by judges' decisions, including a few with Judge Stevens and Judge McNally. We're going to end things with Judge Simpson, where we are wrapping up a couple of stories that we started a long time ago, and one of those is named Miss Tope. Ladies and gentlemen, it's a nutty day, and it all starts right now.
Mr. Lee first, please.
He's not in custody.
Oh, he's not in custody. Oh, I thought he was. Court calls the people of the state of Michigan versus Philip Andrew Liefers, case number 26819FY. Appearances, counsel.
Please sit all for the people.
Good afternoon, Your Honor. Bernard Jockins appearing on behalf of the defendant, Philip Liefers.
So are you Mr. Leffers?
Are we on the record, Your Honor?
We are. Are you Mr. Leffers? Is it Leffers or Liefers?
I am Philip Andrew Liefers, being duly sworn, hereby declare my intentions to be a Michiganian national by birth, but not a citizen of the United States. I am here on special appearance in this case as authorized representative, beneficiary of the estate of Philip Andrew Liefers. I appear before this court without waiving any rights, claims, defenses, or remedies available to me at law, equity, or under trust or fiduciary law. I have my C-Pass.
We can't really hear him.
Sir, can I get you to speak up so that
Yes,
so that we
sorry,
can get a
sir.
clear record?
I have my C-Pass. I have been working very hard to understand and overstand a lot of things in the past. No disrespect, just complete forwardness. I move the court to take judicial notice of the Michigan Constitution of 1850 and the United States Constitution of 1788. And your oath to it, sir.
The yes or no to what?
This is a copy of your oath of office, sir. I don't take anything until the judge tells me to.
Bailiff, I'll take it.
Yes, sir.
Yes, that is my oath of office and has my signature on it from January 22nd, 2025. You can hand it back to him.
I move the court to dismiss this case per canon 2057, which states any administrator or executor that refuses to immediately dissolve a Sesta QB trust upon a person establishing their status and competency is guilty of fraud and fundamental breach of their fiduciary duties, requiring their immediate removal and punishment. And per the United States Constitution, Article 3, Section 2, Clause 2 clearly states that when the state is a party, whether defendant or prosecutor, the Supreme Court has original jurisdiction. Supreme Court decision 1796. There every man is independent of all laws, except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Pruden v. Neely, 2 NC 338, 1796. And don't forget the law of the land, where the general misconception is that any statute passed by legislatures bearing the appearance of law constitutes the law of the land. The U.S. Constitution is the supreme law of the land. And any statute to be valid must be in agreement. It is impossible for a law which violates the Constitution to be valid. This is succinctly stated as follows. All laws which are repugnant to the Constitution are null and void. Marbury versus Madison, 5 U.S. 2 Tranche 137, 174, 176, and 1803. And where rights secured by the Constitution are involved, there can be no rule making or legislation which would abrogate them. Miranda versus Arizona, 384 U.S. 436, page 491. The United States Supreme Court has repetitively held that any judge who acts without jurisdiction is engaged in an act of treason. U.S. versus Will, 499, U.S. 200, 216, S period CT period 471, 66 L edition 2B 392, 406, and 1980. I Cohen versus Virginia, 19 U.S. 6 week 264, 404, 5L edition 257, 1821. 5 USC 556D 557 and 706. Once due process is denied, all jurisdiction ceases. Due process has not been properly followed on. I have not been given full disclosure of everything, including the accounting information, the bid bond, the performance bond, the payment bond, all accounting involved in this, as well as I have not been given the almost 1 hour video of the security footage from Save-A-Lot. Only 14 seconds is what I was informed from Mr. Jockins, and when I asked him for it, he denied me access to it. So I am not being given a fair shot. So I have removed him as my counsel. Please.
Judge, I can't see Mr. Leffers in there. I don't know if the court wanted me to respond.
Sure, let me adjust the camera. I'm sorry for that.
Your Honor, I'm just going to back up and give a little bit of procedural history to the court. I know that the court always reviews the files. I'm just going to explain where I'm at. When I was initially assigned counsel on this case, I took the time and opportunity to review Mr. Leffers and consult with Mr. Leffers, not in person, but I did. With that information that was provided to me and speaking with other witnesses, family members, potentially, I decided it was appropriate to file a motion for a competency evaluation and inevitably criminal responsibility in this action. And the court could take notice to the Mr. Leffer's remarks, motion, etc. Judge, I provide everything, to Mr. Leffers, as I do for all of my clients, and I do follow the Michigan Constitution, the United States Constitution, and every case I have is as important as anything that is going on. With that in mind, Judge, I got notice of this was supposed to be, I believe, on the 7th or 8th of April, and I had contacted the clerk indicating that I didn't think that it was appropriate at that time because we still do not have the evaluation that was returned from the MDHHS regarding the forensic evaluation. And maybe the court can understand the reason why I requested this evaluation, regardless if something was like a ChatGPT sovereign motion. If the court wishes to remove me, I am fine with that. If somebody doesn't want me to represent them, that's fine. But at the same time, I meet all of my obligations and do everything that I am supposed to do with each client, even more so. So with that in mind, Judge, the only concern that I have is that we're still waiting on a forensic evaluation that Mr. Leffers had participated in approximately a calendar week back.
We got the motion, but that, order.
Yeah,
What did I do a calendar week back?
I don't show where I see where, at least I can't put my hands on it now, but I remember you filing a motion. But I have not signed an order for a competency evaluation yet.
Well, with that in mind,
Because-
Judge, I don't know what the court would like to do. If the court would like me to get, I thought that I had provided a competency order, SCAO form. If not, Your Honor, I'm fine with Mr. Leffers proceeding on his own.
Your Honor, I object.
Hold on. Yeah, so I show that there was a motion filed by Mr. Jawkins on March 23rd for motion for evaluation of defendant's competency to stand trial. And actually, I believe it was that same day we received the defendant's motion, Mr. Leffers' notice of self-representation and motion to withdraw. And then the next day, we received an updated copy of that notice of self-representation and motion to withdraw. So I believe this is the first time we're here since these have been filed. And it's generally the court's practice to have a hearing before just granting a competency request. So that was one of the reasons we were here today. So we were actually set for a preliminary examination and these motions. So I believe it obviously is not appropriate to do the prelim today. And so that gets us to the motions. So I guess, Mr. Jawkins, I'm going to turn to you quickly. Your take on the situation. I know you said that you are okay withdrawing, but do you believe that there has been such a breakdown as to require you to withdraw?
Your Honor, I cannot communicate with this individual, and my apologies. When I had communicated with the clerk's office, I was it was indicated that the exam was taken off the docket, and that might have been an email thread as well. So I hope the court doesn't think I'm being deliberately derelict or anything like that. But
no,
these are the reasons why I filed this motion, Judge. But if Mr. Levers would like to proceed on his own, I'm not interested in. I'm the captain of everyone's ship, and I leave it at that. I really, I don't have a good feeling about that when someone files a motion to withdraw, and if I am out there. However, I still think it's appropriate for a competency evaluation. That's the reason why I had filed that, Judge.
All right. Thank you. Now, Mr. It's Leffers or Leafers? I know you said and I apologize.
No. not entering into any.
I understand.
It is old order on a building. Living in Quincy, Illinois. We were there for the Oktoberfest. They do a German exchange in Quincy, Illinois, where I was. Ran into a gentleman, family lineage, and actually tracked down all of the leaders' clan. And he gave me old records from the 16th century. It's Leffers.
Leffers.
Now, it depends on which one you go with. There were over 7 Leffers parents. I do them all together.
Okay.
So, and then I think it was like 80, 100 years later, it jumped to like 13 or 14 in that village.
Okay. So I want to make sure that I'm following your requests. And I understand that you have some arguments as to, one, whether or not the court has lawful jurisdiction, lawful authority, and also a question of whether or not you have been provided with appropriate due process. Couple that with is your request to represent yourself. Am I correct on that?
Yes.
All right. And are you requesting to represent yourself?
Yes.
You do understand that you have the right to have an attorney that either you could hire or that the court would appoint, as opposed to you representing yourself. Do you understand that?
Yes. My creator has placed a lot of friends around me with wonderful information that I never knew. And I'm grateful to know this now. I'm sorry for being caught in dishonor in the past. It will not, Yahuwah willing, happen again. I understand my place, and I have always tried to respect the way that things are. Which is why I need to finish this as well, sir, please.
Go ahead.
And with discovery not being met, there are no medical records, let alone a psych evaluation proving any type of trauma. No harm has been done. No pain has been inflicted and no property was damaged. I have entertained the contract deal of alcohol testing, and I don't drink anymore. And yeah, that was an issue. Not anymore. But in the same token, I can no longer contract with it, knowing that everything's a contract. As you can see from the tests, I even stopped smoking weed and only smoked it right before bed. Since the motorcycle wreck, things have been very uneasy. Trying to sleep at night. Period. Definition of presumption. An idea that is taken to be true on the basis of probability. As a presumption is a presumption on which must be agreed by the parties to be true. Then, and equally, if one party challenges the presumption to be true on the basis of probability, then all that is required to remove the presumption is a formal challenge. That presumption, the presumption, then has no standing or merit in fact. Probability. The extent to which something is probable, the likelihood of something happening in a case. By definition, then, this is not substantial. as it is only a probability of what may be, and therefore has no substance in marital fact. An incorporated state court does not operate according to any true rule of law, but by presumption, color of the law. Therefore, if presumptions presented by the private bar guild are not rebutted, they become fact, are therefore said to stand true. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor beneficiary, agent and agency, incompetence and guilt. Section I. The presumption of public record is that any matter brought before a state court is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is private bar guild business matter, unless stating openly rebuked and rejected by stating clearly the matter is to be on the public record. The matter remains a private bar guild matter completely under the private bar guild rules. I, Philip Andrew Leifers, the undersigned formally challenge the presumption of public record, as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. Section 2I. The presumption of public service is that all the members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild, then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. I am back in place. I do not need a trustee over my estate. Will govern. That's my creator wants me to. I, Philip Andrew Leifers, the undersigned formally challenge the presumption of public service as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. Section 3I. The presumption of public oath is that all members of the private bar guild acting in the capacity of public officials who have sworn a solemn public oath remain bound by that oath and therefore bound to serve honestly, impartiality, and fairly as dictated by their oath. Unless openly challenged and demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must recuse themselves as having a conflict of interest and cannot possibly stand under a public oath. I, Philip Andrew Leifers, the undersigned formally challenge the presumption of public oath as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. IV. The presumption of immunity is that key members of the private bar guild, in the capacity of public officials acting as judges, prosecutors, and magistrates who have sworn a solemn public oath in good faith, are immune from personal claims of injury and liability, unless openly challenged, and their oath demands, as it is here, the presumption stands that the members of the private bar guild as public trustees acting as judges, prosecutors, and magistrates, are immune from any personal accountability for their actions. I, Philip, Andrew, Leapers, the undersigned formally challenge the presumption of immunity, as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. B, the presumption of summons is that by custom and summons, unrebutted stands, and therefore one who attends court is presumed to accept a position, defendant, juror, or witness. In jurisdiction of the court, attendance to court is usually invitation by summons, unless the summons is rejected and returned with a copy of the rejection filed prior to choosing to visit or attend. Jurisdiction and position as the accused and the existence of guilt stands. I, Philip, Andrew. So, short-term memory was wiped out. I, Philip Andrew Leafers, the undersigned formally challenge the presumption of summons as it is by definition a presumption and by definition has no standing or merit in presentable or marital fact. Section B.I. The presumption of custody is that by custom and summons or warrant or arrest, unrebutted stands, and therefore one who attends court is presumed to be a
Judge, I'm sorry, I'm objecting at this point.
and
Right now, there's
Hold on.
nothing that's relevant. This is just rambling and rambling and rambling. Chat GBT, sovereign citizen stuff.
Thing, and therefore
Right, Mr. Leffers, I need you to stop for a second. So, this is what I'm going to do. Mr. Jockins, I'm going to allow you out of the case. So I'll sign an order in that regard. So you're free to go.
Okay, thank you, Judge.
All right, thank you. Now, sir, that I know you have a lot to get out there. One of the things that I have to be concerned with is if you are to represent yourself, that you have the understanding of the court rules and procedure. Now, I know, and admittedly, it's been a while since I've seen this type of material out there, but I have seen it, and I'm familiar with the position that you have, and I understand that you are essentially challenging the authority that one, I have as the judge, two, that this court in totality has, and three, anything that any charges that the prosecutor might have. I can tell you that based on what I'm hearing today, I'm not going to allow you to represent yourself. I don't think, well, I understand that those are your beliefs and your feelings. I don't think that represents a true grasp of the reality of how this republic works, how this state works, and how the court works. And so for you to represent yourself, I think is going to potentially do more harm than good for you. So what I'm going to do, I've, as you've heard, I've allowed Mr. Jockins out of the case. But what I'm going to do is I'm going to make another referral to another attorney for you. All right. It's not that I don't think that you're smart enough to handle the case. That's not it at all. There's some procedural issues here that I don't think you quite grasp how it works. And that is, I'm going to be honest, will probably go to your detriment. And that's and you've got some pretty serious charges here. One of them is a 4-year felony. Means, you could have up to 4 years in prison. So I want to make sure that that you have the appropriate legal representation. And for that, I'm going to deny the request for you to be able to represent yourself. So we'll make another referral to the public defender's office. It might take a little bit of time because for whatever reason, this case went to a conflict attorney, which tells me that the public defender's office has some sort of conflict. What that conflict is, I don't know. But that's how Mr. Jawkins came in. He's a conflict attorney that they work with, so they'll have to reach out and find another attorney for you. Okay.
Your Honor.
Yes.
I move the court to dismiss all charges at the same time. This was case number 26-89-SN-1, which came to fruition because of these false charges that have been placed upon me.
So
State and had the officers actually done their due diligence and looked at the video footage, which is almost an hour long, proving I never ran anyone over, never threatened to, so no harm was done. Everything should have stopped right then and there.
So there's a procedure in which to do that, and there's a proper hearing at which to request a dismissal of the case. That is not today. There's a proper time and place to do that. For what we're here for today, that's not it. Obviously, I can't tell you what that date is or what the procedure is, because that would be giving legal advice that I can't give as a judge, which is another reason why I think I shouldn't say why I think, another reason why I believe that you need to have appointed counsel to assist you with that and to evaluate all the potential discovery issues out there that you've brought up, to evaluate your defense, and to direct in a manner which will be a beneficial outcome for you. So what I'm going to do is we'll reset this case for another day. We'll get another attorney appointed for you, and we'll have that attorney get in contact with you, and then you can discuss with them your concerns and the best procedure for moving forward. Okay?
Problem with that, though. I don't know if it's both sides. I do now. It goes against the Constitution. Even if you have a conflict. So if you want to push this to the Supreme Court, I'll go and stand in front of the Supreme Court.
Well,
I'm okay with that.
that's certainly your prerogative to do that. So, and that's why we have the appellate courts in place.
So I need a ruling, sir. Are you going to dismiss these charges on lack of jurisdiction and a violation of my constitutional rights? Article 3, Section 2, Clause 2.
All right, Mr. Leffers, I have found that I'm not allowing you to represent yourself in the court. So it's not appropriate for me to give a ruling today because I'm not allowing you to represent yourself. That is something that an attorney can assist you with. I will state, as I stated before, today is not the proper time to entertain that request for a dismissal.
All right.
All right. So I'll need
Disrespect. Sorry.
none taken. None taken.
Learning curve. Learning curve.
So you can go out to the front window where you checked in, and you can get your next court date, and hopefully we'll have an attorney appointed for you by that date. All right.
What are you thinking about the dates, sir?
My guess is it's probably going to be next Tuesday. Next Tuesday at, let's reset it for a PCC, 10:30.
What would that date be?
That date is April 21st. Will that work for you?
Yes, sir.
Okay. Like I said, you can go out to the front window where you're checked in and they'll actually give you that paper date. So you'll have that notice. And then, like I said, hopefully we'll have an attorney for you by then. If not, we might have to adjourn it again.
Now, question, because at the same time, can I get the rest of this stuff then? Because it hasn't. I need the accounting, Mr. Dawkins, and in small statement docs. It's almost a video for an hour, but he couldn't get it downloaded, so he recorded with his phone, and apparently it's only 14 seconds.
So
There's a discrepancy among discrepancy, timestamps literally ranging from 5 minutes to stating that I'm at the hospital when I was in the back of Patrol Cruiser 10 at Save-A-Lot. When the officer gave his sworn statement to the magistrate about the warrant after he falsified other information.
So there's a process to go through to request discovery. Your attorney will know that process because you're not representing yourself. That request needs to come through your attorney and through the prosecutor's office, because it's not appropriate for the prosecutor's office to have direct contact with you as well, due to potential ethic concerns and violations for that. So, but yes, you are certainly entitled to that. So whoever your next attorney is, should be able to obtain that and sit down and go through it with you. And then if for whatever reason, if that doesn't happen, there's some other avenues then that attorney can take, or you could come back and request the court to determine whether or not that attorney should be removed as well. All right. Thank you. Have a good day. Don't forget to stop at the front window. Thank you.
19306 is now called the State of Texas versus Amanda Michelle Nolan, which is you.
Yes, sir.
And Mr. Kibler is here representing the state's attorney, and the probation office is here. There is a first amended motion to revoke probation that was filed December 18th, 2025. What are we going to do today?
Well, Your Honor, I guess the state has offered 15 months as an agreement. I advise just to go ahead and just proceed and let the court decide what to do with her. She has had some issues reporting. I think that, in front of the state that she was on, I guess, absconder status at least once or twice. We could just enter pleas and entertain an argument about what to do with her, maybe check her back to. She does have some health issues. She's the court will call.
Who does that?
Well, I think she has kidneys.
You're talking about serious.
Kidney cancer.
Yeah, kidney cancer. I think you've had part of one of her second.
Freshman birthday.
Well, the point,
That's why you're in custody, is that right?
look, number one,
No.
we don't live forever. And sometimes it catches up with us. And early. But what you want to do is, there's not much you can do if our creator or nature has its master plan. Sometimes there's nothing we can do about it. Except what we can do is live our life fully and gracefully and in accordance with the rules.
Yes.
Yeah.
Yeah.
And I'm looking at some medical. It's undated. But it looks. Is this something from jail?
What have you had in jail? What procedures you had in jail?
Did they evaluate you in jail?
They did 2 sessions of ultrasounds where they found more tumors.
Okay, the jail people?
Yes, sir.
Because this is T and K Health. Does that And it's from Oklahoma City, but the way it reads, it must be from the jail. They must have, that's who they must hire to do their medical work, although going to Oklahoma City,
Where were you
that
transferring
doesn't,
for the
It's a
machine?
mobile service.
it's a mobile service.
Yeah, TK helps.
Oh, they go from one jail to another?
That's Riley, just gonna speak with me.
I didn't know what it said.
I said, I'll note that with the infirmary, they have the nursing business named Riley, I'll note that with them, they should take this. If someone's helping me.
The last time we had a hearing, apparently you had pleaded true to allegation 11 of the first amended and 13 of the first amended, but we stopped in the middle of that because I did not complete writing on it because I know how I do I write my initials, date, and true or untrue to the left, and all I put is a true and a duplicate, 2 marks, and then on 11 and 13, and then we ended. So I didn't complete it, which meant something happened. What are we going to do today?
I've cleared tree.
Raise your right hand. Do you solemnly swear or affirm the testimony that you are about to give during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. Can we proceed in summary?
No objection.
Okay. In summary, this states, first amended motion to revoke probation filed on December 18th of last year. It states that on November 18th, 2024, in this criminal district court of Jefferson County, Texas, you were sentenced to 2 years in the state jail, probated for 5 years for theft with 2 or more prior convictions, which the theft was less than $2,500, but it becomes a state jail felony if you have 2 or more previous convictions of a state jail or greater. Is all of that true?
Yes.
Okay.
Allegation 11 again. You failed to report to the Jefferson County Probation Office on or about December 3rd, 2025 and December 4th, 2025, which is a violation of condition 4 of your probation order, which is to report regularly. Is this true or untrue?
Yes, sir.
True.
True.
11, you failed to provide 13, I mean, you failed to provide verification of successfully completing the moral reclamation therapy program as directed by the probation office. Let me ask you about that. On that moral reclamation, she's placed on probation on November 18th, 2024. On moral reclamation, did they go into that pretty quickly into probation?
It depends, so she'll have to buy her book first, when she pays for the book. And then if they have any room available, then they'll put her in the class.
Let me ask this. There's something that I had noted aside. This number 9 violation, have we gotten a scientific analysis back yet that alleges she had phencyclidine, PCP, which is direct from the devil himself, in provided a urine sample in October of last year, which showed the presence of phencyclidine, PCP, in her system. Did we ever get a return on that?
No.
Really?
I don't think it was a case that was ever filed with our office, Your Honor. It was just a urine test.
But we don't we get it showed the scientific showed the okay, what was the scientific analysis or that was done that showed PCP? I don't know. What did they do?
She took me away in office.
Yes,
Checked the positive.
and then y'all test it through your procedure there.
Dipstick.
Well,
Yeah.
well, it's to prove a violation, it only takes a preponderance of the evidence. What about that? Is that true?
Yes, sir.
Say true.
This is number 9, says you provided a urine sample on or about October 21st, 2025, which showed phencyclidine in your system. And that is true?
Yes, sir.
You're pleading true to allegations 9, 11, and 13 of this first amended motion to revoke probation voluntarily and because those are indeed true. Is that true?
Yes, sir.
Do you understand that a knowingly and voluntarily made plea of true to one or more violations of probation, that's all it takes to grant a motion to revoke probation. In this case, your probation can be revoked and you've already been found guilty. You can be sentenced to no less than 180 days up to 2 years in the state jail.
Yes.
Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true, as I find allegations 9, 11, and 13 to be true. All right. Now what? How much time? I'm looking at 106 days.
Just defer to the court.
This theft, what was this? Can you give me some underlying information about this theft? And is there restitution still out there?
No restitution,
Ma'am?
no restitution.
None. Okay.
It's probably, was it a shoplifting case? What was it?
Yeah, I don't see,
From 2019.
I see no fine, no restitution.
What were you shoplifting? What were you?
The makeup to do my mom's funeral makeup.
And they caught you at the door or something?
Yes, sir.
Okay, all right.
The court.
All right.
That's you, and this is not to excuse it, but she was shoplifting makeup to do her mother's funeral makeup.
I know.
Well, I'm not.
I know, and
trying to
it's,
elicit sympathy.
it's just sad all the way around. It's a sad thing all the way around. All right.
Your Honor, I believe it was valued at $39.64.
All right.
But it's okay.
What do we do?
Yes.
I got a recommendation.
Whatever, I'm trusting.
Okay. She's got 106 days.
Yes,
I'll
Judge.
pray for our request to sentence at the lower end.
State's offer on this is 15 months. I stand behind that. I didn't make the offer and
No,
I just got
I'm
that case,
saying-
but that is what the
Yeah, but it's
state is
unagreed.
requesting. It's unagreed, yes, Judge.
When you are released, what are you going to do?
I gotta go have my surgery on March 31st. Go home with my kids, start fresh working and stuff.
UTMB, or you want to get the surgeon?
I was supposed to have it March 31st.
UTMB?
Yeah.
Okay. If nothing further, I'm going to find that there is sufficient evidence supporting this first amended motion to revoke probation to grant it by a preponderance of the evidence or greater as allegations 9, 11, and 13 of the first amended motion to revoke probation is proven true by a preponderance of the evidence or greater. Thus, your probation is hereby revoked. You are now sentenced to confinement in the state jail for 180 days. You'll be given credit for time you've served. And generally, the court does not go on the low end on this under these circumstances, but the documents that the court has concerning the defendant's medical condition is serious, and she needs to get to that soon, to deal with that soon for her well-being and health, which are not the results of any of the allegations that are dealt with in this motion to revoke. So it's natural phenomenon, apparently, but you need to take care of it. Anything else?
We're right.
Not that the state's recommendation isn't unreasonable, but I think for humanitarian reasons all the way around and looking at where the loss is here, which is limited in severity, you need to take care of your health and try to live a long life as possible.
Yes, sir. Thank you.
That is all. Okay.
Does that mean, 74 days left each? I mean, what exactly is there? When you say that?
The county, you got credit for the time you've served, but you've got to serve 180 days. But I don't know how the jail calculates
We'll probably
that.
get released from jail.
From county jail?
It's in the county jail. You're not going to prison.
Oh, so I just finished my time at.
Yeah, they want, I don't think they're gonna send you to, I don't think they do.
Weights laws. So
Be eligible for the 20%, So once we get our paperwork sent over there,
She'd give 20% when she's at the state jail. Though.
well, we'll contact the state jail.
Okay.
And well, I say will, the jail will contact the state jail. They work together really well. So
Gregory Grimstone? Are you Stephen Allen, sir?
Yes, sir.
Okay.
Let's see. That is signed up for a plea.
Sir?
That's signed up for a plea judge.
Okay, what are we doing on this one?
This is a sentencing.
Okay, for the purposes of this motion to revoke probation, correct?
He entered a plea and they requested an updated report. You received that. It was.
So thank you, sir. And you were here with Mr. Kimler, your attorney and the state's attorney earlier, based upon a motion to revoke probation filed as of October 2nd of 2023. We should live so long. And this cause number, we held a hearing finally in February this year, February 6th, and you pleaded true or were found true by a preponderance of the evidence or greater by the court that you failed to report to the probation office on or about September 14th, 2023 in violation of your probation order. And stand by. You had been on probation, on a 10-year probation since 2020 for the third degree felony of evading detention with a motor vehicle.
Yes.
Was he an absconder for a while?
Yes, sir.
For how long?
According to this report, 2 years and
Because this thing was filed
4 months.
October 2nd, 2023, which is 2.5 years ago. And we never got around to the hearing until, I guess you walked off the job essentially on September 14th of 2023 and never found your way back that day. What does it show when he was
Yeah, just a second.
put into custody?
I can find it.
When was the last time the probation saw him?
well, since he posted bond, he has been reporting to the probation
I'm
department.
talking about from the time he stopped reporting until he came back. What period of time is that?
Taking into consideration.
Yeah, he found his way back according to authorities, with authorities' help. See, the thing, you have to report or you're not on probation. That's the essence. You're on supervision or you're not. And I tell them, if you can't do anything else, you got to report.
He was arrested on December 16th, 2025. And after he
But that
He
was over
pled.
2 years from 23 when he last failed to report.
After he pled, he was released on February 9th.
And then he's reported.
How much time do we have on him?
It's not a lot, Your Honor, just doing the real fast math here. It's a little over 2 months. Right at 65 to 70 days.
Get it accurate.
Hmm.
Not much more.
No, I mean, I'm just guesstimating.
Maybe some plea time or something.
That's right.
Like 70,
67.
67.
I included one that didn't get it.
Oh,
Your Honor, at the appropriate time.
Go ahead.
Mr. Renfro wanted to address to give an explanation.
we're ready on what should be done. Who wants to start?
I don't defer.
Go ahead.
Yes, sir. I didn't report. Wow. Actually, what happened, I had COVID. I sent my paperwork into the court. I sent it to Mr. Gary, Harmon, my probation officer. And somehow they didn't get it. I guess I sent an email to Miss Ellie. I sent it to Mr. Harmon.
For 2 years, so.
Oh, yeah,
That's what
yeah, yeah.
explanation is not.
Oh.
For 2 years.
I want to hear it.
But that Mr.
Then
Harmon
don't
told
start
me-
off with once upon a time.
Mr. Harmon had to do his job. He told me over the phone verbally that take care of my fees or whatever, and keep reporting over the phone to him. I know he had a job, he was still marked as not showing up, but I was reporting over the phone to him.
Were you?
She was not there. It was Mr.
Yeah, I don't believe that either, because that's not the way we worked. And COVID was, hold on, COVID was in 2020. And it passed on reporting soon enough. It wasn't for years. And here's this thing, you failed to report September 14th, 2023. It's not COVID. It's not COVID. Come on. And you were gone for 2 years. That's not COVID. It doesn't have anything to do with that. When you first got on probation, it was kind of during COVID. But you were on probation for over 3 years before you just walked off the job. Here's another problem. It's your believability. Contacted the officer on February 11th of this year, stating you would not be able to report for your visit due to lack of transportation and that you would be coming back from Silsbee. So we gave you a new report date 2 days later for February 13th, 2026 at 1:45. You failed to report on February 13th, which prompted the officer to contact you and inquire why you had. Do you remember that?
Yes, sir.
What did you tell them?
I was sick. I provided paperwork. I was sick.
I'm sorry.
I was sick. I provided paperwork to her that I was sick.
No, what did it say? Well, why didn't you report? Where were you that day?
Getting tested for flu.
Okay. Where?
Walgreens on College Street.
That's what you're going to stand by? That's your story?
Yes, sir. I signed it on the
Well, your GPS device doesn't show that. Strangely enough. GPS, you have one, right?
Yes, sir.
Oh, it shows you were not present at Walgreens at that day at all. Also, you reported in February, denied any use of alcohol or drugs, then tested positive for alcohol, and then said, well, that was because I'll tell you now, I did drink alcohol last night. Not until we catch you are you forthcoming.
No, I was
And if you can't be honest with
I was
us,
gonna down-
if you can't be honest with us, because we give a lot of trust to the people, but when the trust is found to be broken, you've lost your credibility. So, according to the probation office, based on your non-compliance and inconsistencies, the officer is reluctant to recommend continuing your probation term. Means, and they're my eyes in the dark. I rely on them. They are close to you. But what I read, I wouldn't trust you either. I think you've broken the trust.
The court said continuing him on probation.
I
I think you said
It
continuing
was-
the probation.
it was- the officer is reluctant to recommend
Oh,
continuing his
So
probation.
does that mean she's reluctantly recommending that he be
No,
continued?
is reluctant to recommend.
Her opinion is he won't be successful because he's repeatedly made
He knows what
the
it is.
same mistake.
He knows what it is. He's playing semantics.
But it doesn't appear that she's ruling that. I'm sure. I just think there may be something like this.
I know the lady and I know what she wants. I know what she's trying to convey. And she's what we all are in this one. We're disappointed.
Yeah, I apologize. I didn't.
You can apologize, but we caught you lying. That can't play well. Anyway.
I recommend the 5-year sentence that was suspended, Judge. The whole reason why we got an updated PSI was the defense counsel represented that there would be something positive for us to go forward with here. And I don't see anything other than just repeated infractions of the same deal. He wants this on his terms and his terms alone, and that's not how we operate, Judge.
The whole thing is bad enough. He failed to report and he was absconding for how long?
2 years and
Yeah.
4
I mean,
months.
that's hard to explain away.
But Your Honor, and Mr. Ham's correct. I always attempt to have some sort of length of time from the plea to the sentencing in order for a probationer to demonstrate their ability to comply with the terms and conditions of probation. So that's what Mr. Renfro had the opportunity to do, and it is what it is as far as his ability or his performance while he was on a bond pending the disposition of the case, and whatever his actions were, I guess, speak for themselves through the probation department. But I would recommend that the case itself, I don't know that 5 would be appropriate, perhaps something less than that.
Well,
Okay.
I mean, he was sentenced to 5.
It was suspended.
I know it was suspended, but
I think we could lessen that, but
You can, but as the state's reviewed this information, Judge, there's no reason to do that.
well, the thing is it's once again, it's if you can't do anything else, you got to report. You have to report, if nothing else. And you were gone. You were AWOL.
did you?
Have you ever been in the army,
PSI.
in the military? Well, when you're AWOL, it's not good.
He wanted to just say what you're gonna say.
When I was absconded, I had an opportunity for a railroad as a job, a train conductor. And I was trying to get that.
I don't care. You were supposed to report. You missed reporting for over 26 times? 26, 27 times in a row.
Hmm.
Nobody does that. And what's good for one is good for all. If I said, okay, I'm passing Mr. Renfro, then everybody would say, I want the Gregory Renfro rule. I can trail off for 2 years and come and wander back and we'll pick up where we left off. I can't do that. If I've always said it, 19 plus years. If you can't do anything, you got to report, or else you're really not on probation. You're on your own probation, which is the tail wagging the dog. It's not working. It doesn't work naturally, right? And and we're 93% success rate. We don't want failure. We're proud of that. We're disappointed. I mean, I'm willing to drag you across the finish line in some cases just to get you finished, but you got to do the heavy lifting. And 2 years plus is a long time. Any of those days, 800 days, any of those days, you could have walked up and said, before y'all go send something, it's gotten the best of me. I'm here and I want to pick up, please have mercy. But no, you got arrested, right? Yes, you got arrested. We had to find you. And that's not the way it should be. Anything else? If not,
Yes.
Yeah, go ahead.
One reason because
yes,
my
sir.
mom died in January And in January is why I didn't drink, so that was the only reason.
It's,
I didn't have time to
look,
breathe in jail.
it's not the drink that's carrying the day. It's the failure to report for 2+ years. That's what carries the day. And no, you should grieve for your mother. You should do that. And I would never punish someone for that. But
I've been having a hard time since losing her.
life includes death. We all have happiness, we all have agony when we lose loved ones, but we just don't quit. And our loved ones wouldn't want that. You loved your mother, I bet. Yeah, me too. It makes me teary-eyed. But your mother would want, but what you want to be is proud for your mother. You know. And here's the deal. You're not going to serve 5 years. I mean, you're going to get paroled here but in months probably rather than years. But it's what you do with the rest of your life. Would it make the spirit of your mother proud or not? That's what you always think. And it's never too late to live a good life in their memory. You ought to be doing it for yourself, though, and your immediate family who depend upon it. But the 5 is the minimum, is what we're dealing with here. Because it was 5 years that was suspended and you were placed on 10 years probation. And yeah, I'm sorry. There you go. Okay, thank you. So, once again, I find there is sufficient evidence supporting this motion to grant it by a preponderance of the evidence or greater, as allegation 1 is proven true by a preponderance of the evidence or greater. And your probation is hereby revoked, you are sentenced to 5 years in prison, and you will be given credit for all time you have served in accordance with this case. And good luck to you, sir.
People against Logan Scott Davis, 25W39 209A. Your name?
Logan Davis.
All right, so what happened is I set a sentencing date. You know what Jessica's number is, Sadie? Hang on, I can see here. I keep forgetting.
218, Judge.
Can you call Sadie, Jessica, and ask her to come in for me, Heather, please?
Yes.
All right, so you have no technical violations, just to recap, Mr. Davis. I sentenced you on November 12th, so it's only been about a little less than 5 months, about 5 months, I suppose. You have on here a variety of different violations. You were in front of me on March the 17th. You pled guilty to failure to pay your fines and costs as ordered, failure to provide proof of completing 24 hours of community service, failing to provide proof of attending AANA twice weekly, and failing to provide proof of attending and completing outpatient treatment. Those are the charges. You pled guilty. Today is the date scheduled for sentence. Wow, you're like bewitched or something. Well, how did you get here already? All right. And today's the date scheduled for sentence. You have the right to a lawyer. Either way, I'm going to appoint you one if you want one. Would you like a lawyer? Okay, so you're going to waive your right to a lawyer?
Yes.
Ms. O'Donnell, you're.
Let's go down there.
So this young man, I told him he better complete his community service, be in treatment, and attend what did I say? Again? Did I say again? Looks like I wrote the word again.
Yeah, you wanted him back attending AA at least twice a week.
When did he stop going to AA twice?
So you wanted him to now provide.
Provided proof now?
I'm hoping he has it in his hand right here.
What are you doing, Mr. Davis?
All right, perfect. So this is proof of AA. Is this supposed to be proof of community service? So this is for community service proof. It's not on letterhead.
You gotta get it on letterhead. Who told you to do that? Where'd you do it at?
Jackson Interfaith Community Shelter.
Does it, there is a name and a contact number.
Let me see
You
it.
can always call.
Let me see it. Mr. Davis. Why? Why?
They didn't have I asked.
They don't have any letterhead over there?
No, I don't. So that's what they told me. They just said bring in a sheet of paper.
You know this Terry Branham?
He's the guy that's at the front.
Did you know him before you started there? Why aren't you taking this seriously?
I am trying my best.
Have you gotten an outpatient treatment?
Yes, Your Honor. I've emailed through. I'm sorry, I didn't send that over to Jessica. I should have, but
Where?
it's in Ewan County. I think it's Ewan County Community Health, I believe.
Can I see the screening? I remember you. This was a bad reckless driving, wasn't it?
There wasn't an accident in this case, Your Honor.
Was or wasn't?
There was not an accident on this case.
Oh, somehow this got reduced, huh? Oh, it was a low breathalyzer. Did you start on your GED?
I have not yet, Your Honor.
Why not? You're not taking me very seriously.
I'm trying to take.
This is 5 months ago I told you to do this.
I understand.
We don't have forever for you to be placed on probation. You understand?
Yes.
Your lawyer did a good job on this, and he convinced the prosecutor. I think he filed a motion. I don't remember what happened here, but to say you got lucky is an understatement.
I apologize.
Don't apologize. I'm not going to jail if I send you today. You don't have to apologize to me. It's your life. If you want to do this to yourself, I mean, I don't get it. You're laid off.
I'm currently in care.
Where?
I work at Scare Force Spa.
How long were you laid off?
I was laid off for a period of, I believe, about 6 months.
So what were you doing then? Were you collecting unemployment?
I attempted to, but I could.
Why weren't you working? I'm serious as a heart attack. You're 23 or 4 now. I mean, you can go through life not working if you want. A lot of people do it. They seem to be able to eat. I don't know how. I really don't, but
I just didn't have a license around it, and it just snowballed.
Why didn't you have a license?
Yeah, they're suspended, I believe. But
Your license was suspended as a result of the 2020 conviction. You have a valid license. I know you got suspended after the reckless, but the reckless you took a plea on back on October 29th.
yes, I got laid off in about August. So it was about a period of a month. I thought I was going to go to work, but I just didn't want to do that. There's not all word from me.
Can you give me some good news on him?
He's showing up for testing. This testing's negative.
Did he do any AA after the offense date before I ordered him to or told him he was going to have to after I took the plea on the probation violation on March 17th? So do we have any evidence he did any AA or NA between November and March 17th?
I don't have any proof on me unless we have it and didn't submit it to me. I don't.
Did you go?
I don't have proof that I did go around.
You did go, but you didn't have it. You didn't have it signed, right?
I have the paper. I lost track of the paper.
Lost track of the paper.
Yeah, the original. I was going originally.
When did you lose the paper?
Leave about November-ish.
November-ish. Well, if you lost the paper in November-ish, why didn't you go between November and March?
Didn't have a way to make it to, I didn't.
It's getting worse. I'm shocked that you didn't take me seriously. I must have done a poor job. Can you hand this back to him, please? Or back to Jessica? You had a prior impaired. Now this is a reckless driving. This is not good. It isn't only the fact that you had several violations, the 4 violations here. It's that you just didn't take this seriously at all.
I applied with everything, and after I was going to get a license, it was going again.
I can't solve your problems for you.
I understand.
You got yourself into this predicament. You don't get to blow off court orders. I don't care if you have to take a bicycle there. I don't care if you have to walk there. I'm sorry. It isn't that you missed a few AA. You just, as far as I'm concerned, never went. And if you did somehow go, and if somehow I didn't believe you, which I don't, you should have started in November again. And now you're telling me you went and you lost your paper, but you didn't have a ride to go after November, which tells me you didn't go before November, after the sentencing, and after I ordered the bond conditions in September. I'll tell you what, we're not going to get along very well, you and me.
I apologize.
Don't apologize to me. You don't have to apologize to me. I just don't like the total lack of compliance here. And that's what we have. You didn't get an outpatient. You didn't do your AA. You didn't do anything. Now you do your community service.
I've done all of that now.
I know you have. I saw it. If that's valid, I want you to confirm that. What do you think?
Again, I think he's, putting things off. He gave me a call, I believe, last week, maybe the week prior, for the number to call to get treatment. Again, that's something he should have done a lot sooner than that. Again, something I told him right after his hearing, he should have done within the next couple of days after that. So that does concern me that he's putting these things off.
You've ended up with a revoked license had your lawyer not been able to negotiate this for you. I don't remember how. It was a low breathalyzer, I'll give you that. But this is just not appropriate. I'm sorry. I don't usually do this. You're going to jail today for 6 days. You're going to pay costs of $125. You're going to grow up right now, or you and I are not going to get along. Okay? You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I'll let you set up terms of payment. I don't care if you do it there or wherever you do it. Probation to set up terms of payment. He's behind. Work with them. If you don't have the money, like I told you, you call the court. Did I not tell you that? Hang on. Did I not tell you if you didn't have the money on a due date to call the court, you'd go on Zoom, I'd give you an extension?
Yes, sir.
I told you I didn't care how many times we had to do that, right?
Yes, sir.
You're very immature, folks. You got to get them on the right bandwagon. I'm glad and appreciative of the fact that you came here. He's underachieving. He knows that I know it. You need to go get a high school diploma or a GED. You need to maintain employment. You need to complete your treatment. And you need to do everything else that I told you in a timely fashion. This is not do it as you feel like it. I wish you well. I'm sorry you made me do this. Good luck. Have a seat over there in the jury box. People against Brandt. Paul Alonzo Brandt the fourth. 24B87519. Could I have seated up here? Why are we doing this with Sleeman? Did you take this back to him, John?
did, Your Honor, and just gave everything.
I want him to come in here when I'm ready to call him. Your name?
Paul Brady fourth.
All right. You're charged with failure to attend the scheduled probation visit, August 21, 2020. You're charged with failure to complete the positive strategies program. You're charged with failure to provide proof of completing 3 days of community service by August 1 of 25. Those are the charges. If you plead guilty or are found guilty, since you failed to appear back in September, you've absconded. You could get 90 days on this. Your probation revoked, even though you even though you only have, well, either way, you have one prior technical violation. So I guess if you convicted all of these, you still could have your probation revoked. Do you understand that?
Yes, sir.
Did you sign the advice of rights and read it and understand it?
Yes, sir.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand?
Yes, sir.
You have the right to a lawyer. I'll be happy to provide you with one today at public expense. Do you understand it?
Yes, sir.
Would you like a lawyer?
No, sir.
Are you sure?
Yes, sir.
To the charge you failed to attend the scheduled probation visit on August 21 or 25, how do you plead?
Responsible.
It's guilty or not guilty? Okay, so I'm asking again, if the charge failure to attend the scheduled probation visit on August 21 to 25, how do you plead?
Guilty.
You failed to attend your probation visit on that day.
Yes, sir.
Count two, that you failed to complete the positive strategies program, how do you plead?
Guilty.
You failed to complete the positive strategies program.
Yes, sir.
To the charge that you failed to provide proof of completing 3 days of community service by August 21, 25, how do you plead to that?
Guilty.
Anybody force you to plead guilty?
No, sir.
And you failed to complete your community service by that date?
Correct.
You still wish to proceed without a lawyer?
Yes, sir.
I'm going to accept your plea as to all 3 counts. I find they've been made voluntarily and understandingly. Can you call him Sergeant Bernars if you have his word? Oh, I see what he did. No, that's okay. All right, why don't you have a seat? I don't need Bernars. I misread this. You're all set. Have a seat right there at the table. I'm accepting your guilty pleas. Against Paul Brandt. Paul Alonzo Brandt the fourth, 2487519. Your name?
Paul Brady fourth.
I don't know what to do with you. I mean, I sit there and I look at you and I see a nice kid and I just, your name? You still wish to waive your right to a lawyer?
Yes.
What are you doing? What are you doing?
That's a rough patch in my life.
Tell me. I want to know because you didn't show up in February. You didn't show up in September. I'm not a fan of people ignoring courts.
I lost my job at the end of last year. Following that, me and my family of 4 lost our house. Currently residing with my grandmother. I have another newborn due.
Slow down a second. Slow down. 1 second. Heather, I've got this other file. I just want to make sure the DNR is out there.
They're out there.
Okay. So I'm going to do them in this order. If they want to just stay muted, you can tell them. I'm doing Mr. Brant's. Then Mr. Harper has a ton of these. I hope he's got a lot of money with him. And then I'm going to do the DNR signing on record. Let's start over. Okay? Tell me what you wanted to say. What's the rough patch?
At the end of last year, I lost my plumbing job at the Plumbing Pros out of Livonia, Michigan.
What year? You said last year, but what month?
The end of 2025.
Okay, so just 3 months, 4 months ago.
Correct.
Okay.
Following that immediately, just a couple weeks after, I fell behind on my rent. The mobile home complex we're staying in Newport, so me and my family lost our home as well. We moved in.
Who's your family?
My fiance and my 2 sons.
Did you have them with her?
Yes, I did.
Go ahead.
Me and my fiance and my family moved in with their grandmother. Found another plumbing job with Trent's Plumbing out of Downriver, Michigan.
What plumbing?
Trent's Plumbing,
Okay,
and that's in the downriver area. I'm now employed with him. I'm trying to get caught up on finding a new house, being that I have an eviction on my record is making it very, very hard for me and my family to move. Being that money is very, very tight, we're trying to save as much as we can to get out there and south as fast as possible. We have a baby due in the beginning of July.
so now you got a third one coming?
Correct, in the beginning of July. I'm trying to make most.
So you just decided you're gonna blow this off?
I didn't, I had, there's a lot of things going on in between the house, custody with my youngest son, there's a couple different things going on.
Custody? I thought you were living amicably with the mother of the child.
My oldest is with my fiance, I have a middle child, with another, mother, who had my, newborn, which is gonna be born in July with the same one. So my middle son, Paul, I have, custody
You
issues.
got things going on all over, aren't you?
I would like to get this.
Did you hear what I said to you?
What was
You
that?
got a lot going on.
Yes, sir.
I mean, I don't have any problem with you. Tell me, Judge, I've enjoyed juggling balls, but you got a lot going on. You blew this off.
So with the custody stuff with my son, it was very important with.
Of course it was. Did anybody tell you just blow this off and focus on the custody issues and everything else you got going? Gotta watch. I don't understand. I don't know what to say. I mean, I don't really have any choice. You're leaving me with no choice here. Probation is set to expire. Well, I guess we have 6 more months. You didn't pay, did he pay his restitution?
Yes, Judge. Or no, I'm sorry. There's $128.19 left on restitution.
That should have been paid back into the area to do it.
Oh, you lost your job. Wasn't this, you had a fraudulent scheme involving a plumber?
Correct. That's a completely different story.
Well, I don't want to hear the story anymore. We already covered that, but you're stealing or engaging in fraudulent schemes. You're not taking care of your probation.
Scheme is a misunderstanding, yeah.
Well, I took a plea, and I know how I do things, and I know I wouldn't have taken the plea if there wasn't a basis to take the plea. Why'd you miss your probation visit in August of 25? Why didn't you complete the positive strategies program? Why didn't you complete your 3 days of community service by August 1 of 25?
I was trying to find a new job. I was trying to find a place for.
You gotta grow up. You gotta grow up trying to find a new, what are you talking about? Trying to, what? So would you put in 42 applications every day? I mean, give me a break. Grow up. You sound like a little. I'm telling you, I was trying to find a new job. Toughen up. You gotta toughen up. I hate this when people have sound like this. You know that? I just can't stand it. Probation is supposed to be over on November, is it November 29th of 25? I skipped 12 months.
Yes, 12 months. He would have been off on November, I think, 9th, 25, Your Honor. I think sentencing is November 19th of 24.
I hate to see young people ruin their lives like this. It bothers me. Shouldn't bother me. I mean, you're not my kid. but you're acting like somebody that needs to really toughen up. I was looking for a job. What do you mean you were looking for a job? Somehow, some way, I find it impossible to believe that you were looking so hard for a job that you couldn't find, that you couldn't do the whopping 3 days of community service that was supposed to be done by August 1 to 25. You fathered 2 kids with a third one on the way. You just got kicked out of a mobile. You need to get tough. You need to get tough. World doesn't owe you a living. I'm just disappointed. You seem like a nice kid. I don't remember you. But I cannot excuse what you've done here. Any thoughts, Ms. Wilds?
The only thing I see, of course, was casino supervised, Mr. Brandt. Is the previous violation mimics this. This would be the second time he absconded, the second time that he was given an opportunity to comply with these exact same terms and conditions. I have nothing for you, Your Honor, as far as I don't think it's appropriate to continue probation. We're just gonna do this, for a third, so to say.
Is this your fiance?
Yes, Judge.
She's right. Life punches us in the mouth a lot. It really does. It really, really does. And to me, I don't know what to tell you except you gotta toughen up. I mean, it's a cruel world out there. It's a cruel world out there. There's anger, there's animosity. You get it. You had children, and you have a responsibility to them 100 times more than you do to yourself to provide them with a roof over their head, a stable environment where they're not going mobile home to grandma's, to anybody else's, to clothe them, to feed them, to teach them right. And how can you teach them right if you're not teaching yourself right, or obviously haven't been taught? Now, I can do one of two things. I can just throw the book away and you can go sit in jail for 60 days if you want. I got no problem with you telling me that. There's something that makes me think that maybe you're worth taking a chance on again, but you're still going to jail today. Now, I think you got it. I'm telling you, I cannot emphasize this enough. Did you graduate? Graduate. Did you have, were your parents, were you living with parents?
I was living with my grandmother through my childhood, and I had kids at a young age.
Where were your parents at?
What was that?
Where were your parents? So where'd they go? Do you have any idea?
My mother still lives in the general area, but I don't talk to either of my
Nice. I was, the one thing I just can't imagine. This is the problem we have going on. Can't imagine what I'd have to do. One of my kids would have to do to me for me not to talk to him again or not to stay in touch with him. I can't imagine. They'd have to run me over with the car and then be laughing at me when I'm on life support. It's the problem we have going on in society, not enough caring parents. So for that reason, here's what I'm doing. I believe that you can do this. I want you to finish your probation. You're going to jail today for 7 days. I'm extending your probation until I get it. It's hard to care for people when you didn't have anybody care about you, right? So what I'm doing is I'm extending probation until July the 29th of 24. Probation is extended until July 29th of 24. which should, is it, I'm having a hard time reading my writing on the sentencing. Is it the 26th or 29th?
I have November 19 of 24
Yeah, see, I can't read my.
that he was sentenced.
He was.
November 19 of
He was.
24.
So then it's July the 19th of 26. And that means we're extending probation for a period of 8 months. I'm going to reduce your probation fees from 160 to 100. Defendant to serve 7 days now. You got an obligation. I don't know what it is about you. I think you're worth saving, but you got to take care of your business. I'm going to have him go to jail for 7 days, and you are to have this done. Defendant to complete community service and positive strategies program by, today is April the 14th. I'm going to make it June the 15th. Do not disappoint me. If you come back here or you abscond again, you will get every day you have coming.
We need his new address too, Your Honor.
I'm gonna let you get that from him. Will you do that for me?
Yeah.
You have 21 days to appeal, 14 days to apply
I have one question.
for a court-appointed lawyer. No, I'm not changing my mind on the jail.
No, it was a question. How many days do I have to complete the community service?
I thought I said June 15th. Did I not? Maybe not. Let me double check. I
I'm
thought
not mistaken. Online classes that I have to take as well. So I don't know if 3 weeks.
and yeah, if you, what's that?
I don't know if 3 weeks is enough time.
I'm giving you until June 15th. This is April 14th.
I'm sorry.
So that's okay. So you got 61 days roughly, or 62 days to complete it, 61 or 2. So anyway, yeah, get going. You're in custody. Have a seat. Good luck. Aaron James Harford, 25B14851. You got to toughen up, son.
Court does call the case of the people of the state versus Sharon Van Fieldmore. Counsel, state your appearance.
Good afternoon, Your Honor. Katie Rosmersky for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sean Moore, who is present in court. Please state your name for the court.
Sharon Moore. Thank you. And date and time set for sentencing. And the parties, are they ready to proceed?
We are. Your Honor.
Yes, Your Honor, we're ready to proceed.
All righty. Whoever would like to go first? Do people have anything that they would like to say before I do impose? Not that you have to, but.
I appreciate that, Your Honor. I don't have much to say, except to underscore that we arrived here because these charges are ultimately what was supported by both the facts and the law. We appreciate the court's efforts in communicating with both sides. Your Honor, we trust this court's decision-making as it comes to imposing a sentence. And so I don't have anything to say in terms of what we want you to impose or what we expect for you to impose. I trust that. I do, however, feel that I would be remiss in my duty if I did not underscore for the court and for the record that there was a young woman that was deeply impacted by the defendant's choices on December 10th of last year. I just want to make sure that we state that for the record, and I am confident that Your Honor will take that into consideration to the extent that it is important and appropriate and necessary in imposing your sentence. And I appreciate that opportunity. Thank you.
Counsel?
Much.
Just so that we're clear on the record, you received a copy of the pre-sentence investigation and report.
I have. I will address that when I get to the podium.
All right, very good.
Good afternoon. Good afternoon. First and foremost, with regards to the pre-sentence investigation report that was submitted to me by your probation department, there are no additions, corrections, or deletions. There are a few things that I would like this court to know about Sharon Moore. Sharon Moore is the only child of immigrant parents who came to this country for a better life. He grew up in a home marked by uncertainty. His father, an Air Force serviceman, was deployed overseas for long stretches, leaving his mother to carry all the responsibilities at home. That shaped him. It taught him resilience, responsibility, and the importance of family. Sharon didn't always fit in. He was bullied as a kid and often kept to himself. Sports changed that. It gave him confidence, direction, and ultimately a purpose. That purpose became coaching, not for attention or status, but to help young men grow on the field and off. He teaches that success comes from facing challenges head on and handling adversity the right way. I have come to know Sharon over the last few months. I have seen how he responds when things are at their hardest. He has handled adversity with grace and with dignity. Since this incident, Sharon has engaged in counseling, gained insight into his life, and developed tools to guide him forward. He has recentered himself around his family, and he has taken responsibility, expressing genuine remorse to those closest to him, the people most affected by his actions. Your Honor, this is a man who is not defined by this moment, but by how he has responded to it. For these reasons, I ask this court to grant a deferral and place Sharon Moore on probation. It is an appropriate sentence given the nature of the offense and Sharon Moore's lack of any prior criminal history. Thank you very much. Thank you.
Because it was a no contest plea, I just want to make sure for purposes of the record, Mr. Moore does not wish to address the court. Is that correct?
That is correct.
All right.
Yes. I apologize. He has a short statement to make to the court, which you'll do now.
Your Honor, first of all, I want to thank my Lord and Savior Jesus Christ for his grace and guidance during this difficult time. I want to thank my beautiful wife, Kelly, for her support, her strength, and standing by me. I want to thank this court and its staff for their time and consideration. I'm grateful to my attorney, Ella Michaels, for her guidance. I've taken this process very seriously and work closely with the probation department to prepare for today's sentencing. I'm ready to proceed. Thank you.
There was nothing additional from probation, is it?
That is correct.
Thank you, Mr. Laird. Before I impose the sentence in this case, I think that there are a few things from this court's perspective that I think need to be pointed out of the purpose here of what the court's going to do and what the court's not going to do. I want to make it very clear that the morality of what transpired, that's not something for the court to decide. I am not passing judgment on that course of conduct. I may have my own views on that, but I'm not here to pass judgment on it. That's way above, frankly, my pay grade. At some point regarding the conduct that is not before this court, the morality of it and the like, going to ultimately be left to this defendant and his God to make that determination, as well as the grace and forgiveness that might be bestowed upon him, if deserving, by his wife. What the court is also not doing, and what is not my role here, not part of my bailiwick, and it seems to have been so pervasive in this case, is to put a thumb on the scale of what might be future litigation involving the University of Michigan. That is not my That is not the world or realm I'm operating in at this particular point in time, and not part of this judgment and what I end up with. I think it's also important to point out, because I don't look at the news very much, but in looking at how people may misinterpret what has occurred here. And I want and feel it necessary to make that clear. There are certainly those that believe that as the charges were initially filed, the 3 charges of home invasion third, the stalking charge, and the entry without permission charge, that there's a view that they shouldn't have been filed. And then there's a view that, well, should have stuck with it. I will commend counsel on this case because I think they have both shown courage, but particularly I want to address the Washtenaw County Prosecutor's Office and their courage in doing what is right. The reality of this case is the people, if they had wanted to, I would imagine, could have just decided to proceed with this case and just let the chips fall where they may. I think, as Mr. Sminsky stated before, that is not their obligation. Their obligation is to do justice and to do what is right. The very beginning of this case, so that people can understand it, the facts as they knew them supported the filing of the charges. I've been fortunate or unfortunate in this case to be able to see a lot more than I would in a normal case. This having been a no contest plea and a lot of information being provided to this court to determine whether or not there was a factual basis. But I want to make it clear that when the charges were filed, they were appropriate. But as with any case, as more facts become known and as more things happen, the facts and the analysis change. Now, I don't say any of what I'm about to say to try to bash anybody or to do anything, but I say it for the purposes of so that people can understand what the prosecutor's office was looking at. They had filed these 3 charges. The first 2, the first being the home invasion third, and then the stalking charge, with the belief that on the 8th of December, 2025, that Ms. Shiver had informed Mr. Moore that some way that she no longer wanted content. Now, with that, certainly they may be able to proceed with, if there's attempted contact or other things that can occur by Mr. Moore's conduct, that people may have been able to proceed with a stalking charge. Stop for a moment and just tell you that what is called a predicate offense, or the underlying offense for the home invasion third, the misdemeanor, along with a home invasion or entering a home, that the stalking charge had to be maintained. But here's what the people found out. And I will say that when the police, Pittsfield Township, are interviewing and they're going through, they are, I watched, I don't know how many hours of video in this case. And I will tell you that they were not only professional, they attempted to try to get to the bottom of it. At some points, their efforts seemed thwarted. That's my view. And that they were trying to get answers to a lot of different things. But as It was presented to them and they ultimately presented to the prosecutor. On the 8th of December, Shiver had indicated in her own words to them that at, I believe she said 6 a.m., or I think she specified that at 6:10 a.m., had told him that there wasn't going to be any more contact. And then any contact or attempted contacts, anything along those lines, would then potentially constitute a stalking charge. When the police department asked for Miss Shriver's phone, and I'm not saying that this is Miss Shriver because she didn't have possession of her phone, they wanted the call logs. They never got them. And there may have been a reason for that. I don't know. But they never got the call logs for the phone. But maybe there were those that thought if they didn't have the call logs, maybe they wouldn't be able to see certain things. Well, maybe to many chagrin, there's such things as search warrants and other where one can get these logs. And I go back to the 8th, because again, I want to explain why the people did what they did. The 8th at 6:10, 6 a.m., there is supposedly this communication to Mr. Moore that he should no longer have any contact. Problem was that could not have been true. And the reason it couldn't have been true and what the people saw is that after a call on the 7th, approximately for over an hour, well, for 83 minutes between Ms. Shiver and Mr. Moore. After that call, when it gets to the 8th, and remember, it's 6 a.m. is what the people are told. There was a call at 2:49 p.m. connected for 7 between Mr. Moore and Ms. Shiver. There was then an additional call at 3:29 p.m. that connected for 4 minutes between Mr. Moore and Ms. Shiver. Those are outgoing calls from Mr. Moore to her. At 3:41 p.m. on that date, there is an incoming call from her to him for 11 minutes. There is then at 7:41 p.m. an outgoing call for 27 minutes from Mr. Moore to Ms. Shiver. Here's what the people realized. The very foundation of the stalking charge, which would have been the telling not to contact me on the 8th, there is no call on the 8th. But the very foundation, it couldn't have happened. The people realized that when they got that information. Bottom line, by necessity then, the stalking charge would fail. If the stalking charge fails, it being the predicate for the felony also had to fail. And the people knew this, and they did the right thing by making sure that that charge did not go forth. Because in good faith, legally, morally, ethically, they could not proceed on that. And they knew it. They didn't try to hide the ball. They didn't try to do any of that. They didn't say, well, we're still going ahead. We're just going to put them through the paper. They didn't do any of that. They did the right thing. The third charge, which was the illegal entry to the premises, also had its problems. And I'm not going to go through sort of an extended analysis, but suffice it to say that Mr. Moore had access to those premises. That access was granted by Ms. Shiver. She gave him the code to the door. It wasn't just a key. He had the code to enter the premises. People in analyzing it said they weren't going to proceed on that either, because that was inconsistent with what was being told to them. Now, having said that, I hope that people can understand why this case ended up where it. At that point, when I have to say from the defense side, there may have been those that would have just proceeded with the case, let it become back as a not guilty and try to be done with it, but that's not what they did. They realized that there were certain wrongs that had occurred. The parties came together, and there certainly between them were decisions on what charges would be appropriate. After reviewing everything so that people understand, it was reviewed by the prosecutor, got reviewed by the defense, and this court itself reviewed all of the reports. The right thing happened. The charges, the criminal charges that this defendant, Mr. Moore, would have been guilty of, he pled to. No more, no less. In any sentencing, it is important that the court consider a number of different factors. I look at the defendant. I look at the effect that cheating in the defendant's conduct had on the victim in the case, in this case, Ms. Schreiber. And in that, try to come to a resolution in my mind as to what would be an appropriate sentence. In this state, there are impact statements that are given so that the court can hear the victim and the victim's voice, the one that was wronged by the conduct, so that you could hear. I truly would have preferred to hear Ms. Schreiber's voice much more clearly and much more directly. I regrettably, rightly or wrongly, legitimately or not, her voice for the court to hear has been clouded. But through my probation department and the like, I have a sense of what are concerns for Ms. Schreiber. One of those concerns is that she won't be heard, and that the defendant will not be held accountable in any way. And it was interesting to me that there was communication to the court prior to the victim's impact statement that I was not aware of prior to receiving the communication that had occurred in this courtroom. I was not on the bench at the time. But where an individual who Ms. Schreiber and her people believed were part of the court had gone up to Mr. Moore, shook his hand, and gave him a hug. I want to make it real clear so that it's the individual that did that was a member of the sheriff's office here, is not a member of the court, is in no way connected to me or this court, and that I was not even aware that I was not in the room. I actually had to go and see it online. That should never have occurred. Not because it didn't have or would have had an effect on this court. Shouldn't have occurred because of its appearance of occurring. Assure Ms. Schreiber that there's no impact on me, and that having been brought to my attention, I will be dealing with those in the sheriff's office regarding that conduct, because it can't happen here. So that's one thing. But Schreiber also asked for the strictest punishment that this court could give. Incarceration is usually left to those times where an individual, this court would continues to pose a risk to society or others. Or that this court believes can't in some way conform themselves to the norms of how we should operate in society. I don't believe, as I look at the entirety of this case, that incarceration would be an appropriate sentence in this case. Now, having said that, should there be, and I think that a probationary sentence is appropriate, but should there be a violation? And I will send my direct warning to you, Mr. Moore, that should there be a violation, all bets are off to date. I don't like sending people to jail, but I will not have a problem with it. As the prosecutor has indicated, this court is very mindful that that day, December 10th, a number of things happened that changed people's lives. In imposing a probationary sentence, I would let Ms. Shiver know that this court is not by any means lessening the impact of those events. Frankly, Mr. Moore, you had no right to do what you did. I know that she was placed in fear. It was a traumatic experience that day for you. It was certainly a traumatic experience for her, but you had no right to spread your pain to her. And as I was going through this sentence, and there were a number of letters, a number of things presented to the court in attempting to try to decide upon the appropriate sentence. There is a certain irony in a lot of this. And it's a big one, in my opinion. The person, quite frankly, Mr. Moore, that is saving you from the full wrath of this court is the one you betrayed. I don't know where your wife, Kelly, finds her strength. When all of the circumstances are happening, and they're happening to her, and she's absorbing them in real time. She not once loses her focus. She not once bats an eye to sort of doubt you. She not once wants something terrible to happen. As I listened to the terror in her voice that day, I don't think there would be anybody in the world that, given all of the circumstances, would have blamed her if she just said, I don't care. It's not what she did. She didn't know where you were, but she was going to tell the police, try to do this to find him. She said something that was remarkable, and that is just tell him I love him and to come home. Incredible. And when you see, and you know, So I'm listening on one of the calls, listening to her. I can hear your babies in the background. She's what she had to deal with was just an incredible burden. She didn't bat an eye. The letter that she wrote to the court, and there were a number of them. And like I said, I went through all of them. Certainly had the biggest impact on this court and what I should impose. I figure certain ways that she was just pointing forward, leaning on her faith, and trying to put her family and find a way forward for her family, which was inclusive of you. I think in life, sometimes people take a lot for granted. You, sir, take her for granted. I am amazed by you, Miss Moore. Truly am. I don't know where it comes from. I think, in all honesty, given all the hurt and pain, that if we had more people like you in the world, I may be out of a job, but I think this world would be a better place. Therefore, the sentence of the court as to count 4, that I'm going to place the defendant on an 18-month probationary term, months under the prosecutor deferred sentence. You are to pay $555 fines and court costs. We will take those court costs out of the bond. You are to pay $540 probation oversight fees. Those will also be taken from the bond. There is to be no use of any alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to continue mental health treatment, follow all recommended care, the status reports to probation. You are to have no contact with Paige Shriver, directly or indirectly, to any third parties. You are not to refer to her on the internet. You are not to communicate her using any electronic device. Am I clear on that, sir? Sure. You are not to go to any residence or employment of Paige Shriver. There is to be no assaultive, threatening, or intimidating behavior. There's to be no possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll schedule a review hearing that will be held April 14th. Actually, the date is going to change, is it not, Ms. Camara?
Yes, Your Honor, it will be October 13th, 2027.
October 13th, 2027, 9 a.m. I will order 180 days in jail, credit for the 3 days you served. The balance is suspended. As to count 5 to trespassing, I will also place you on 18 months probationary term, 18 months under the prosecutor deferred sentence. You're to pay $250 fines and costs. That will be taken out of the bond. You are to comply with all terms as set forth and what I have enunciated in count 4. I will order 30 days in jail, credit for 3 days. The balance is suspended. To the people, is there anything else from the people?
No, Your Honor, thank you.
Anything else from the defense?
No, Your Honor.
All right. Thank you very much. Good luck, everyone. Court stands in recess. All rise. Fixing Housing versus Erica and Aaron Ward in regard to the matter of the show cause of Tope. Can you hear me? Oh. Can you hear me?
I can.
Okay, very good. State your name, please.
Yes. I, Donna Tope, for and by myself, come before this court to say that there is no basis for holding me in contempt of court.
Ms. Tope, I'm going to cut you short.
Okay.
I'm going to just indicate that I read your response. While I don't necessarily agree with what's in there, I don't think it's going to be incumbent upon the court or upon you to further hold you to go ahead with the show cause at this juncture. The case has been dismissed. It's over. My understanding is that there was regrettably a foreclosure. The horses are now elsewhere. And so I'm no longer going to proceed. I'm going to dismiss the show cause without prejudice. So it could come back, but it's unlikely. Thank you.
Thank you.
I'll go back.
All right.
He's not.
That's it. 14A stands in recess.
That just happened. After all that, just dismissed outright. I have a good feeling listening to some other people pontificate on the situation. I have a good feeling that the good judge has a pretty good idea that there are other things happening in the background that render whatever his decision might be moot. So I figure the fact that nothing really happened with all of that right there is not surprising, because again, just hypothesizing out here, if for some reason there was some type of thing going on where she was facing some type of disciplinary action in the background, or she was voluntarily relinquishing her license, something like that was going on, his decision there just wouldn't matter. So he's moved on with his life, and it's kind of interesting. I put those things in that order because I really feel it's an opportunity for us to see the judge taking his own advice in some regard. Anyway, Tope is Tope. What's done is done. We're wrapping up the stories of Mr. Moore and Donna Tope all in the same day. And we started things off with a sovereign citizen. I mean, come on. Herschel's here somewhere. I don't know where, actually, at all. Sorry, Wicks, I'm still no membership. I see you asking. Guys, as always, I am your lone wolf Usul. I'm the guy who puts all these together, and I was running late tonight. I do apologize, but we got things put together. It was all pretty tight. Thank you all for coming and hanging out. Marty says Tope's not really done. He could be right. You know, she had a lot going. There were a lot of irons in the fire. Not just in Simpson's Court either. So, but until tomorrow, same wolf time, same wolf channel. I'm gonna be putting some stuff together. Hope you guys stick around. See what I throw out there. Hope you enjoy whatever it might be. I'll be going crazy releasing stuff like a madman, because that's all I know how to do these days, apparently. Ladies and gentlemen, thank you very much for coming and hanging out with me. I will see you next time. I'm your lone wolf Usul, and for now, I am out. Oh yeah, maybe I should give you those times like 8 p.m. Central Time, 9 p.m. Eastern Time. Hey, yeah. Thank you, BM Cougar. Thank you, Living Like a Cat. Thank you, Julie, Sassy, I, Low, Kierna, Shiloh. How many other names do I see on this? Oh. Big thank you to Living Like a Cat, Wixom, and our friend Sovereign Legal Encounters Hutch, my friend. Thank you so much. I don't know what else to say. Have a good night. You know, as I do my little sign off in memoriam to Ferris Bueller's Day Off, I'm reminded of a thing Tennessee Williams once said. Friends are God's apologies for our families. Y'all have a very good night, ladies and gentlemen. Thank you for being friends.